We've spent a lot of time over the past month talking about how the government shutdown is affecting executive branch agencies, but it's a big issue for the federal judicial branch, too. The Administrative Office of the U.S. Courts recently announced the judiciary has exhausted the funding it needs to keep all court operations up and running, so courts are having to make individual decisions about what activities continue during a shutdown. Nick Boyle is partner at the law firm Latham Watkins. He's here to talk more about those impacts. Okay, Nick, and as I understand it, that the same basic law that governs the executive branch, the Anti-Deficiency Act during shutdowns, applies to the judicial branch too, but a pretty different situation in that courts tend to have a fair amount of autonomy. Is that a fair read? And what do we know so far about how the Anti-Deficiency Act and the expiration of funds here is affecting the judiciary?
Yes, that's a fair read. There is a significant amount of autonomy in the court system. What's happening is that there's been a bit of divergence court by court as funding has run out. So, as you probably know, there was a period where non-appropriated funds could be used by courts. So that's things like the balances in court fee accounts, for example. At this point, that funding has essentially been exhausted, and courts are making different decisions on, whether to stay open, what to prioritize, et cetera, depending on things like their caseload or what type of cases that they might take. So you're seeing a little bit of divergence.
One of the things that you all point out in your latest update on this is that the district court level, they're indicating that they'll sort of prioritize the resolution of cases. What is not being prioritized? And I know the answer is going to be a lot of it depends, depending on the district court. But what is, what goes into that resolution of cases bucket in an obvious way, and what doesn't?
Sure. So one very obvious distinction between the core systems is that some are staying open for 5 days a week and some are not. And so what that means is the funnel has narrowed. And so even if all cases are being resolved, in some places it's just going to take longer. So to take an example, Southern District of California has said we're open 5 days a week. Rhode Island, Connecticut, Alaska, other districts have said we're going down to 4 days a week. So whatever the matter is, it's gonna take longer. And in terms of how courts are triaging between what they are going to address in a more sort of timely manner, it's what you would expect in terms of TROs and PIs and habeas matters and things that are time sensitive are going to get prioritized. By contrast, take the District of Columbia, where Chief Judge Boasberg has said if there are civil cases involving government attorneys, essentially none of those are going forward. So it again a little bit depends court to court. If it's like a habeas matter, those are going to go forward everywhere. If it's a government matter and you're in the District of Columbia, that's not going to go forward. In other districts where, frankly, there are less government civil cases, that decision is going to be made on a case-by-case basis.
Yeah, you completely read my mind. That's where I was going next, because there's this other big population of government employees that are involved in a lot of these cases from the Justice Department, both AUSAs and other litigators. I imagine it in those other non-DC district courts that you mentioned, this is going to be coming up more and more in the criminal context where you need at least a federal prosecutor to be participating. Are we seeing impacts on the criminal dockets yet?
We haven't seen that yet. Criminal cases are generally in the bucket of the types of case that are getting full attention from the court system for obvious reasons. So on the criminal side, we haven't seen any significant impact yet.
But I imagine in a lot of these cases, especially on the civil side, even if the court's got the bandwidth and the funding to keep going, you could see a lot of cases where the government requests a continuance because they may not have the personnel to staff a courtroom. Is that something we're seeing crop up?
Yeah, that's exactly right. And as you might expect, given the circumstances, those requests, as far as we can see, are generally being granted unless there's a very good reason not to. But yes, in those courts where there hasn't been a blanket stay on those cases, judges are very open to granting a stay. I mean, not least because law clerks are not being paid. As I said, there are multiple courts where they're only open 4 days a week. So anything they can do to decrease the pipeline, they're going to do. So those requests are almost always being granted.
Yeah, in terms of the personnel who would be accepted or not here and who's being unpaid during this whole episode in the judicial branch. I mean, people's minds go to judges and clerks. Who else should we be thinking about in the judicial branch who is not being paid and may not be working that could impact how the judicial system operates right now?
Well, judges are accepted because they have Article 3 constitutional
Ah,
status, so they're being paid. So they're in a sort of different bucket. Law clerks, my understanding is, are generally not being paid. There is a under the statute, the anti-deficiency statute, there's an exception for matters that are essentially necessary for the functioning of the system. So payments are available to make sure that Pacer is up and running, to make sure that the electronic filing system is up and running. So the the structure remains in place. There are sufficient funds are still available under the Anti-Deficiency Act to make sure that where courts still wish to hear the cases, payments are available. So that I think if you want to feel some sympathy, I would definitely direct it to people involved in litigants involved in civil cases where the government is on the other side, and to those law clerks who are generally working but not being paid.
makes sense. And I think we've focused so far quite a bit at the district court level. Is it basically a similar story in, let's say, bankruptcy courts and circuit courts, a lot of case by case?
Circuit courts, I'm not actually aware of any circuit court yet deciding to go, for example, to a 4 day week, which, as I said, is happening around district courts. Circuit courts appear to be open. What we're hearing anecdotally with respect to bankruptcy courts is care is being taken to make sure that if a hearing needs to be held in order, that assets are not somehow dissipated or lost. Prioritization is being given on a case by case basis.